Last name is Castillo. First name is Roberto.
Did we do it already? Okay. Oh, you ready?
I am.
Okay. Roberto Castillo, come up.
I've been in Montgomery County this morning, so I'm so late.
That's okay. You're not late. Good morning, Mr. Castillo. Sir, you stand charged with the offense of driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney.
It's New Year's Day, 4 a.m., and a routine DWI stop is about to spiral into a full-blown legal debate. A case of alcohol, evasion, or maybe overreach. Stay tuned.
To avoid the officer's patrol vehicle. The officer initiated a traffic stop on Tomball Parkway, and upon contact with the defendant, the driver and sole occupant of the vehicle, the officer observed glossy red eyes, slurred speech, odor of alcoholic beverage, and the defendant stated he had a 6-pack of beer approximately 4 hours prior. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant was—
Here's something to chew on those field sobriety tests. 6/6.
Field sobriety scores like this, 6 of 6, 6 of 8, are nearly airtight for probable cause. But here's the twist: should refusing a blood test automatically lead to a warrant? Drop your opinion below.
signed and executed.
What was the stop for?
Allow me to read the DIMS, Your Honor, to see if he specified. So according to the officer, the vehicle pulled into a parking lot and then exited in an attempt to navigate away, and the vehicle crossed through the parking lot onto another roadway. And that appears to be all the officer put in the DIMS.
Tell me what he did wrong. What code?
Notice how the judge pushes back. What law was actually violated? That's key. Officers can't just rely on instincts, they need a concrete statute. Otherwise, the entire stop risks collapse.
I mean, I can give you a little bit of time if you
Give us
want.
more time, Your Honor, so I can look at this.
Can you give me 5-10 minutes, Owen?
Sorry, Judge, I have other cases in buildings.
Okay.
I agree with the court. Even if they allege that he was attempting to, if he cut across, there is a violation for cutting across in order to avoid a traffic control device, but they didn't allege that. All they've got is him turning into a parking lot and then back onto another street. So that's not a law violation.
Like 10 minutes and we can.
Yep, go to it.
Thank you.
All right. Just take a seat. Don't leave. And then when you come back, we'll finish.
I'm back on Mr. Castillo. Let's see here.
All right.
Yes, Judge. So in regard to the crossing the parking lot, it was the officer's understanding, I spoke with the officer, that crossing the parking lot is a violation because he crossed right through, and the traffic code that we found is transportation code.
Hold on. Did you take a look at this?
The prosecution leans on section 545.423, crossing property without stopping. But the defense strikes, intent matters. Was it to avoid a traffic device or just a nervous turn? One word changes the whole case.
May not cross a sidewalk or drive through a driveway, parking lot, or business or residential entrance without stopping the vehicle. And the officer said that he crossed, according to the DIMS, he crossed straight through onto the public roadway. And speaking with the officer, he repeated that as well, saying that he was at a slow roll and he just went straight through upon noticing the officer. And that's whenever he performed the traffic stop, as he crossed that parking lot.
An operator may not cross a sidewalk or drive through a driveway, parking lot, or business or residential entrance without stopping the vehicle.
Yes, Judge. And as
he never stopped at all.
Correct. And as the DIMS states, the vehicle pulled into the parking lot and exited the parking lot in an attempt to navigate away from the patrol vehicle. So he just entered and exited. He didn't stop.
First, Judge, that statute requires that you're doing it for the purpose of avoiding the traffic control device. There's an additional element.
Really?
See the back and forth? One side insists or, the other argues and. This isn't nitpicking, it's statutory interpretation. Small wording battles like this decide whether evidence stands or falls.
A. B says an operator may not cross or drive in or on a sidewalk, driveway, parking lot, business, or residential entrance at an intersection to turn right or left from one highway to another highway.
In order to avoid the traffic control device.
Correct, but that looks like it's an or, not and. Or, unless you show me unless you can show me differently. I mean,
It is an or, Judge. I agree with that. However, may I address another issue?
of course.
If you listen to the DIM summary, he says he intended to stop my client to begin with. Then my client, in order to evade him, rolled across the parking lot. There's no explanation as to why he started attempting to stop my client.
The defense lands a heavy blow. Why did the officer even want to stop Castillo in the first place? If the stop lacks a clear reason, everything after might be tossed as fruit of the poison tree.
Your Honor, the DIMS reads
It's certainly interesting.
It reads different because it says while the officer was patrolling, he observed the vehicle, and it immediately goes into how the vehicle pulled into the parking lot and exited in an attempt to navigate away from the officer's patrol vehicle. And after that point, it says the officer initiated his patrol lights. So he wasn't attempting to stop him at the point that he entered the parking lot. All the officer articulated was that he was attempting to navigate away from his vehicle.
I mean, what it sounds like to me is he sees the officer and just tries to get away. And then the officer sees him do something that's maybe a violation of the transportation code and pulls him over right there. Had he kept driving and just gone straight, perhaps would have never been pulled over. But the virtue of the fact that you go and do that, if there wasn't a violation, I would kick it all day. But I mean, May
I address one other very shortly?
Please.
The way he says in his DIM summary, he says, the purpose for crossing is to evade me. He is thinking this man is trying to evade me. And that certainly implies that he was trying to stop the defendant before the defendant turned into the parking lot. Otherwise, why would he say he was trying to evade me? In other words, if he's consciously thinking this man is evading me, he's doing something that would lead the defendant to evade.
I agree with you.
So without showing it.
Smart judging here, probable cause found for now, but the door left open to video evidence. Rare move, keeping both sides honest. Do you think the officer acted on true suspicion or just a hunch?
I agree with you. But the fact remains is he went through. And it looks like he may have indeed violated that part of the transportation code. Now, pull the video. If the video shows you something differently, come back and we can do PC again. I'm always happy to revisit it. But perhaps if he would have kept going and not done anything, not done that, he wouldn't have gotten pulled over. If he would have, and nothing had done, there had been no errors, then you know what would have happened.
Understood.
I'm going to find probable cause for now. What was the last name again?
Castillo.
Okay, Mr. Castillo, I'm going to find probable cause. And let me tell you, you speak English, right?
Yes, sir.
And by no means does this mean that you're guilty of this offense. This just means that there's enough to go forward now. That's all it means. You got a great lawyer who will handle the case for you. If there are always any issues, you guys can come back and reapproach and we can go from there. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to revoke your bond. Okay. As long as you have a valid Texas driver license and liability insurance, you may continue to drive.
It's eligible, Your Honor.
Great. You have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but just stay in contact.
The judge set strict bond conditions: no alcohol, no drugs, random testing. It's a reminder, pretrial freedom comes with strings. Slip up once, and that bond evaporates fast.
If your bond conditions, and then you guys are free to go. Thanks, of course.
Right this way.
Wow, he just picked up an Agasol. Saw that, huh?
Christopher Duran?
We had a lot of issues with him, Lori. Many, many issues. No, you can be on probation.
Go straight through.
All right, bring it.
All right, page 19, Lopez, come on up.
Good morning, Mr. Lopez.
Sir.
Sir, you were charged with theft. You're facing up to 6 months in jail and/or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 31st, 2024, an officer was dispatched to HEB in Harris County, Texas regarding a shoplift that had just occurred. The officer made contact with the complainant. The complainant is the manager of the HEB and observed the defendant Diaz and defendant Lopez walk through selecting merchandise and place items inside of a red HEB bag and communicate with one another and place items inside backpacks they came inside the store with and roll up the red HEB bag and place it on the bottom rack of the cart. Defendant Lopez paid for 3 items left in the cart. Defendant Diaz went inside the bathroom and reemerged after defendant Lopez paid for the items. Neither defendant
Switching gears, a theft case at HEB, bagging groceries, but not paying. The detail? Security locked the doors before confronting them. Bold move, but was it legal containment or false imprisonment?
from the store management and security in opposite directions. Defendant Lopez was identified by his name and date of birth.
Okay. Mr. Lopez, I'm going to find that there's probable cause to go forward with the case. The co-defendant is the co-defendant in our court?
We had him last week.
He's in here? Okay. I'm ordering you as a condition of your bond not to go to any HEB. Do you understand? If I find that you go to any HEB, if I find that you pick up a new case, if I find you have contact with the co-defendant, I'm going to revoke the bond, put you in jail. No more PR bonds. Do you understand?
Your Honor,
What do you do for a living, sir?
I'm currently looking for a job. Yeah.
I'll have you fill out an application for an appointed lawyer. I am ordering you as a condition of your bond not to consume alcohol or illegal drugs as well. If I find that you're using, it's not going to go well. Do you understand?
Your Honor.
Judge, you have an important call.
Are you still in trial? Say it again. Oh, Sarah, Rich. Yeah. You done? How was it? Wow, congrats. What did you try?
DWI.
Nice. Yeah, he was telling me, we're all big fans. Good job. Yeah. Mr. Stoll, I was waiting for you. How are you, man? You ready?
Yeah, we're ready. My internet's not really working for this, but.
What do you need?
We're just gonna do pre-PC and bond conditions real quick.
Okay.
And get, Mr. Duran out of here.
Good morning, Mr. Duran. Mr. Duran, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Officers were working in undercover capacity, and they advised,
Now we're shifting gears racing charges. But check this out.
Now, racing on a highway. The officer defines a rolling drag race, but here's the issue, he never clearly he saw side-by-side acceleration. Definition versus observation, does a gap like that sink the case?
race with a yellow Corvette, unknown license plate. Rolling drag races when two or more vehicles align their vehicles from their moving position while traveling side by side on the public roadway. Vehicles then simultaneously accelerate forward at a high rate of speed, attempting to outdistance and outgain each other in a competition of speed. The black Jeep and the yellow Corvette were heading west on the highway at 40 miles per hour.
A Jeep versus a Corvette?
Right.
He was in the
Hey,
Jeep,
really?
Your Honor. He was in the Jeep.
And accelerated at a high rate of speed of 90 in a 65 miles per hour zone.
There versus a tortoise.
They maintained visual on the vehicle, observing it exit the highway and enter into the parking lot of a Buc-ee's. They approached the driver of the Jeep. The defendant here stated he knew why he was in the parking lot and he was just trying to have fun.
Your Honor, in the DIMS report, the officer does give the definition of what a roll race, what a drag race is. However, just after that, when he closes the the caption of where the definition is, he never says that he ever witnessed my client and the Corvette line up side by side and accelerate from a point side by side in order to outdistance the other vehicle.
Didn't you say that they like kind of slowed to some kind of like next to each other and then they flew out? I thought I heard that.
Yes, because as the DIMS is written, the officer says he observed the black Jeep, the defendant's vehicle, engaged in that rolling drag race. Then he goes on to define what he meant by that. And that's when he says they slowed and they went side by side and they accelerated.
I think it's a poorly written DIMS, in my opinion. I think it would have been better had he
Well,
said,
but I guess he's trying to explain to us, hey, what this is, because not many people may know, but I saw them engage in this.
Yes, sir.
Right.
And this just happened 3 days ago, so we're
Right,
gonna wait for the
so
offense.
we are still
report.
waiting for the full offense.
Nevertheless,
Right.
that's what happened is they kind of slow down and then they take off, right?
Yes, sir.
Yes, Judge.
Okay. Do we have the co-defendant? No?
There was, he was the only one.
All right. Mr. Duran, I'm going to find that there's probable cause to go forward with the case. Have you guys run his license to see if he has a valid Texas driver license?
All right.
He does, Your Honor.
Please. Okay. No more. 610 is not the place to do this, and I'm making that a condition of your bond. There are proper places in Houston, but not on our freeways. Do you understand?
Yes, sir.
I'm making that a condition of your bond. If I find that you're doing it again, first thing I'm going to do is I'm going to put you in jail. The next thing I'm going to take your ability to drive away. Living in this city without the ability to drive sucks. All right, come on, no more. You understand? You've got a great lawyer. Listen to Mr. Stoll. He'll take care of you. I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Mr. Stoll and he'll tell you when you have to come back to court.
Okay.
If he tells me he can't get a hold of you, you pick up a new case. I'm going to end up revoking your bond. All right, guys, please. So he can't leave until he signs conditions and then he can do it. Can you file,
Still no reckless, no racing, those type of conditions. Yes, Judge.
et cetera? Yeah.
Raven Landry? No, these are for the state, correct?
State, yeah. Is it Tyren? No,
Yes.
please. Mr. Collins, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 31st, 2024, at 2:35 p.m., an officer was dispatched to 12600 Dunlap Street, Houston, Harris County, Texas, in reference to a disturbance unknown weapon call. Upon arrival, the officer made contact with the complainant, who stated the defendant is her son and that he assaulted her. The complainant stated she lives in an apartment with her 2 sons. The complainant stated that a month ago she asked the defendant, her eldest son, to help pay for rent, and the defendant agreed to pay a certain amount. The complainant stated she got tired of asking and told them that she was not renewing her lease. The complainant told the defendant he needed to move out by December 31st. On that day, she arrived at the apartment to turn her keys in and do a walkthrough with the complex manager, the witness. The complainant stated as she was removing the locks from the doors, the defendant pushed her with both hands.
This one hits differently, a son accused of shoving and punching his mother over rent. Family violence charges carry heavier consequences, especially with protective orders. How should courts balance punishment with fractured family ties?
No threatening or harassing contact, and that he not be able to go near her new residence.
Got it. Okay, Mr. Collins, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your, well, hold on a second, let me see. It looks like a protective order was issued on the 1st of this month. I would get to know it, because if you violate this protective order, the state can and probably will file a violation of protective order. It's one of the worst cases you can pick up. You violate conditions on a VPO, I can have a hearing to hold you at no bond, 0 bond, and I will do it in a heartbeat to protect my community. Do you understand?
Yes, I also had a witness too.
Stop. You will get the opportunity to fight. Now's not the time. I got a bunch of DAs here. I don't want you to say something. You'll get the opportunity. Just now's not the time. I am ordering you as a condition of your bond not to have any threatening or harassing contact with the complaining witness in this case. Understand what is threatening or harassing doesn't matter what you think. I could care less. It's what she perceives. So if I go like this, is that threatening, harassing? It most certainly is. And it can be a basis to revoke your bond. Do you understand?
Yeah.
All right. Tell me, what do you do for a living, Mr. Collins?
I work.
Do you have enough money in that work to hire a lawyer?
No.
Tell me about what you do then.
I work as an HVAC tech.
All right. So what I can do is I can give you an application. I need you to fill it out. Don't just put zeros, because I'm going to send it right back to you. I need you to fill it out. Be honest. I'll take a look. And if you qualify, then I'll give you a lawyer. I am going to file conditions that you're not having threatening or harassing contact with mom. It's mom?
Mom and Judge, the protective order says no going within 200 feet of her previous residence. She gave me her new address. So if we
Okay.
could
Do you want to
add
refile it?
it. We could. Do you know how to do
Put the correct address in the MOA? You want them? Let me just, and all right, I'll print it out. We'll just amend it. I need to know, or I'll give it to you. You put the correct address.
Yes, Judge.
So, Mr. Collins, you're not allowed to go where she lives. Do you understand? If you go there, I'm going to revoke your bond. I'm going to put you in jail. You need to understand, if you don't have anyone that's going to pony up $5,000, $10,000 to get you out of jail, you'll be stuck like Chuck in there until this thing is over with. Consider that when you're out there in the free world. I'm not asking for much. Just don't become a danger to our public. Don't violate conditions. That's it. All right. Stephen, do you mind giving an application? Do you mind filing no threatening or harassing contact and no weapons?
Approved already, so
Okay, so all they need is the application?
you need the application.
Okay, it's old, so what we'll do, we'll give you just a couple weeks. Got to be here at the next setting, everything done. We'll send it for a TRAS at the next setting, and then we'll go from there. Huh? Yep, okay. Yes, ma'am. Thanks. Hey,
Morning, Honor. Happy New Year.
what's up, man? Happy New Year. I wanted to wait for you, so we didn't.
I appreciate that. Yeah, I have Mr. Copeland. He will waive PC on it.
Okay.
So, all good?
Any priors?
No, DWI first.
Okay, so just same as usual, just no drugs, no alcohol, if you don't have a license, no driving, and all that jazz. Done.
All right, thank you very much. Good to see you.
You too. Yes, sir.
Eric Spitz, are you ready, Judge?
Say it again.
Eric Spitz, we hope we-
Okay, I'm ready when you are. Is this a true first?
I'll just move my down to it first.
Right, but it's not a second though.
Oh, that's fine.
It's not a second.
It is a second, but it's being pled down.
Right, it was charged as a second.
From DWI disputes to racing charges and even family violence, today's docket showed just how varied and emotional court can get. What's your take on these rulings? Drop a comment, hit like, and subscribe for more courtroom breakdowns.